Hello, guys and gals. This is the Bar Exam and Chill podcast. I'm your host, TJ, and today we've got a question from the California Bar Exam from July 2024. Let's look at the questions before we jump into the hypo. So we've got here question 1. What property interest, if any, does Darla have in Lot B? Discuss. 2. What claims may Simon make to maintain a right-of-way over Lot B to the public highway? Discuss. So this should tell us that we're probably in a property hypo, and let's jump in. Olivia owned Greenacre in fee simple. Greenacre consisted of two unimproved adjoining lots, Lot A and Lot B. A dirt road led from Lot A across Lot B to a public highway. 60 years ago, Olivia conveyed Lot B to Barry as a gift, subject to the following clause. If at any time Barry, his heirs, successors, or assigns shall use the premises for any purpose other than as a personal residence, said Lot B shall immediately vest in fee simple in Zach or his surviving descendants. Shortly after receiving title, Barry began living in a cottage he built on Lot B. At the time of the conveyance of Lot B, Zach had not yet had any children. Zach has since died, and his granddaughter, Darla, is now his only surviving descendant. 30 years ago, Olivia died. Her son, Simon, inherited Lot A. He built a house on Lot A 1 year later. Through the years, Simon regularly used the dirt road across Barry's adjacent Lot B to get to and from his house and the public highway because there was no other access. 4 months ago, Barry sold Lot B to developer for $1 million. Developer demolished the cottage, began constructing an office building on the lot, and began closing off access to the dirt road from Simon's house. All conveyances were properly recorded immediately after execution and delivery. All right, let's jump into question 1. What property interest, if any, does Darla have in Lot B? Otherwise stated, the issue here is what estates and future interests were created by Olivia's conveyance of Lot B to Barry, and does Darla hold any valid interest in Lot B today, particularly after Barry's sale to developer for commercial use? Or does Darla have a valid property interest in Lot B based on the personal residence restriction? Or is her interest void under the Rule Against Perpetuities? So we've got a Rule Against Perpetuities question. This is somewhat rare, but you have to be aware of the Rule Against Perpetuities because it has appeared on both the California and the UBE bar exams within the past, 5-10 years. It comes up every once in a while. So basically, there's like this one rule statement that you just want to memorize. Even though the Rule Against Perpetuities is kind of difficult, you're going to get points if you just have this one rule statement down, right? So you just have to know the statement, no interest is valid unless it must vest, if at all, no later than 21 years after a life and being at time of creation of the interest. That's the common law rule. So as long as you have that one sentence memorized, even if you misapply the actual law on the exam, you're going to get some points. So you set up, you say, hey, here's the issue. Basically, does Darla hold any valid interest in Lot B today? And then you're going to split into all this property language. We're going to go through that right now. So you've got a fee simple absolute, right? That's the present possessory estate of potentially infinite duration. It's fully alienable, divisible, descendable. This is you owning it outright. It's actually kind of just yours in perpetuity, right? And then in property, you have these defeasible fees. These get split out into different terminology that we're going to go through. So fee simple that may terminate on a condition, basically. If it's a defeasible fee, the fee is the fee simple absolute. If it's defeasible, it's just saying, it can go to somebody else based on certain, if it could go to a third party, or it could revert back to the grantor, or there could be right to reentry. These are all terms of art that you're going to have to know on the property exam. You're probably going to have to just sit down and actively study the nuances here, but we're going to go through it. So you've got a fee simple subject to executory limitation, or fee simple subject to executory interest. This automatically divests and shifts to a third party, not a grantor. That's the key. So if you have this kind of defeasible fee simple subject to an executory interest, it's going to go to a third party upon a condition. You're going to have language like if, shall, then to third party. Could be a corporation, or it could be another person that's not like the grantor or the person that holds the interest in fee simple. provided otherwise to third party. This is the kind of language that you're going to be looking out for. And you've also got what we call a shifting executory interest. This is a future interest held by a third party that shifts the estate from one grantee to another upon a condition. This is a future interest in a third party that divests a prior grantee, not the grantor, upon the condition. So we've got these property terms here, and then also, again, our rule for the rule against perpetuities here. No interest is valid unless it must vest, if at all, no later than 21 years after a life in being at the time of creation. You want to just have that sentence, that one sentence memorized. In California, which is what this bar exam question is coming from, it's a jurisdiction where they have what's called the wait and see doctrine. You're going to want to know the common law rule, which is that sentence, no interest is valid unless it must vest, blah, blah, blah. But you've also got this wait and see doctrine. That's kind of how it works in California. You basically just wait and see for a 90-year period. If the rule against perpetuities is violated, the offending interest is stricken. Conveyance otherwise stands, often leaving grantor's heirs with a reversion or right of entry. So we're going to have this rule against perpetuities, and we're going to discuss it basically in the hypo, but let's kind of go into this rule against perpetuities. How does this work? This no interest is valid unless it must vest, if at all, no later than 21 years. I'm going to go outside the hypo and just kind of try and describe how this actual rule works. So let's kind of imagine that we've got like a rich grandpa. He's dying. He's pissed at your cousin Chad. Chad's always getting drunk, and he's puking on the family yacht, having parties, messing it up. Grandpa writes in his will. He says, I leave my giant beach mansion to Chad in fee simple, but if at any time Chad or any of his descendants ever stops using the mansion as a personal residence and instead turns it into a weed dispensary, then the property shall immediately go to my other grandson, Kevin, or Kevin's surviving descendants. This is a shifting executory interest, right? It's possibly shifting it to this third party. And let's talk about, where does RAP, this rule against perpetuities, kick in? So at the moment Grandpa dies, the lives in being are everyone alive right then when Grandpa dies. You, Chad, Kevin, all these people that possibly are going to these parties that Chad's throwing. The rule against perpetuity says Kevin's future interest must vest or fall within 21 years of at least one of those people that are currently alive at the time that Grandpa dies. So what's the problem? Well, what if Chad lives to be 105 and then he has a kid at 104, right? Let's say he's taking Viagra. And that kid waits until he's 50 to open the world's greatest, mansion, beach dispensary. By then, every person alive when Grandpa died has probably been dead for decades. So Kevin's interest might not vest for 80 plus years, way over the 21 after the last life in being at time of the creation of the interest. This would be a rule against perpetuities violation. So the result would be that the court would strike out the gift to Kevin and his descendants. Chad now owns the mansion in fee simple, or possibly subject to a right of entry in Grandpa's heirs. And he can legally turn it into the dispensary in town without fear of it being snatched away generations later. So the rule against perpetuity, in plain terms, is kind of the law's way of saying we're not letting rich dead people control land and fuck with title forever down the line, like immortal property dictators. That's kind of what the rule against perpetuities is designed to get around. I mean, you have all these like modern ways to get around it, like with trusts and dynastic trusts and all this stuff. Buy, borrow, die is another way, So it's basically irrelevant, I guess. But we still have to learn it for the bar exam. So you've got the rule against perpetuities. We've gone through it with kind of our own little side hypo to try and understand what's going on here. Another thing to note here is restraints on alienation. This actually comes from there's a provision in the California Civil Code. There are conditions, so conditions restraining alienation, just meaning you have limitations on being able to sell a property. Those are going to be void if unreasonable. So you have this reasonability test. Again, I think I said this in one of these earlier episodes. If you ever have to bullshit a rule in the bar exam really quickly, like you just get blown out and you're not sure of a rule, just throw in reasonable a bunch and you might, your odds of hitting may be pretty high. So you cannot have absolute restraints on alienation. That's just kind of a rule. You can't just be like, you can never sell this thing. So that's good to know. future interests are descendable, divisible, alienable, unless they're limited, right? So let's go into the application for this question 1 here, where we're analyzing Darla's interest in the hypo that we've got. Olivia conveyed lot B, part of her fee simple absolute in Greenacre, to Barry, subject to this clause. And let's analyze the clause. If at any time Barry, his heirs, successors, or assigns shall use the premises for any purpose other than as a personal residence, said lot B shall immediately vest in fee simple in Zach or his surviving descendants. So this is the language that we're analyzing on this hypo that we've got in the California bar exam here. This language creates in Barry a fee simple subject to an executory interest. So we'd want to probably, have a little bolded header there, fee simple subject to an executory interest, and just define that defeasible fee that Barry has under the language of what we've got in the hypo here. The condition is a use restriction, right? That's kind of what this is. It's saying it has to be a personal residence only. So that would be called a use restriction. Upon breach, which is a non-residential use, then the estate is going to automatically shift to Zach or his surviving descendants. That's where we get this language. This is a shifting executory interest in the third-party grantees, not a reversion to Olivia. So Olivia started with fee simple absolute in both lots. It's the highest form of ownership. She's got it forever. It's present possessory, infinite duration, fully transferable. So Olivia's got this fee simple absolute. When she conveyed lot B, she did not give Barry fee simple absolute. She attached a condition that limits his ownership, right? We've got that conveyance language. If at any time Barry, his heirs, successors, or assigns shall use the premises for any other purpose than a personal residence, said lot B shall immediately vest in fee simple in Zach or his surviving descendants. That's a classic defeasible fee. All right, so why does Barry get a fee simple subject to executory limitation? Let's just kind of go into that a little bit more. He receives a present possessory fee simple estate. He can live there, build a cottage, use it for residential purposes, but it's subject to this condition where if he doesn't use it as a personal residence, then it's going to shift to this third party, Zach and his heirs. That makes it defeasible. It can be defeated or terminated, right? So that's where the language is coming from here. Why Zach and later Darla get a shifting executory interest? So an executory interest is a future interest held by a third party, not the grantor, that becomes possessory upon the happening of a stated condition. It shifts because it divests, cuts short the estate of a prior grantee. Here it's Barry, right? Barry's this grantee, and it shifts possession to this third party. So let's get into our wrap analysis here for this question. At creation, which was 60 years ago, Zach was alive, right? A life in being. Though at the time, he's childless. So the interest in Zach or his surviving descendants is contingent upon A, Zach having descendants, and B, the condition non-residential use occurring. Under strict common law rule against perpetuities, it might violate because vesting could occur remotely, which means far beyond that 21 years, if Barry never breaches until long after Zach's death. However, under a wait and see, right, which is, we would want to make this distinction in our essay here for the hypo, we would want to lay out that common law rule, say, hey, this possibly violates because of the reasons just stated, and you've also got this California, how does it treat the rule against perpetuities? Well, it has this wait and see doctrine. So you're going to wait for 90 years and see if it vests. So we wait to see if it actually vests within that 90-year period in California. The breach occurred around 60 years later. This is in our hypo when Barry sold to developer and non-residential construction began. Thus, the interest likely vested validly in Zach's surviving descendant, who is Darla. All right, great. So at common law here, the interest was likely void. The condition at any time could happen centuries later, far beyond 21 years after the death of Olivia, and you analyze at the time of the creation of the interest, right? So could be 21 years after the deaths of Olivia, Barry, or Zach. So we've got the common law rule. Seems like it may violate the rule against perpetuities, but under California's 90-year wait and see rule or wait and see doctrine, the interest is currently valid. The conveyance happened 60 years ago. Since the triggering event building an office building occurred within that 90-year window, the interest is vested in time. So you're going to have two possibilities you're going to want to discuss here with regards to the rule against perpetuities. In this hypo, you can say under the common law, likely violates the rule against perpetuities, and you're going to want to put that, right, because you have to know this common law rule. And then under the California 90-year wait and see doctrine, it looks like it's going to be valid because it vested within that window that's allowable. All right, so conclusion on number 1, Darla holds fee simple absolute in Lot B, assuming wait and see rule against perpetuities validation here. Under strict rule against perpetuities, she might have nothing, right, with Olivia's heirs possibly holding a right of entry. So you've got that distinction on the conclusion here. The developer's purchase and development triggered the shift. All interests were recorded, so the developer had notice, right? It gives us that at the very end there. It says, hey, just assume that they properly did everything and recorded the interest and so on. All right, so we've got our rule against perpetuities. Damn, we did it. Hopefully it wasn't too terrible. That can pop up, and it's good to have, you know, that property language in the defeasible fees. You're going to want to have really clear in your mind for the bar exam what exactly is right of entry, reversion, the subject to an executory interest. There's a springing executory interest. So you want to have all that nuance down in your head before you take the bar exam. We've got our rule against perpetuities down here. We answered. Let's jump into question 2. This is what claims may Simon make to maintain a right of way over Lot B to the public highway. So issue rule application conclusion. Our issue here is, does Simon, who's the owner of Lot A, have any easement? And here's our easements. You could have express, implied, by necessity, or prescription. Those are your kinds of easements, right? You're going to want to know all of those. We're going to go through them, but each one of those types of easements you're going to want to have down for the bar exam. So does Simon, owner of Lot A, have any easement, express, implied, by necessity, or prescription over the dirt road on Lot B, now owned by the developer, or Darla? Okay, so let's get our rule outlines here. For an easement is a non-possessory right to use another's land. So you've got two kinds, right? The dominant estate, that's the one that is, you know, benefiting, and the servient estate, which is the lesser little bitch estate. So you've got non-possessory right to use another's land for a specific purpose, which is usually access. If it's appurtenant, that means it benefits the dominant land and runs with it. And you've also got in gross, which you kind of want to just think like gross. That's like, you know, an accounting term. Here, it just means that the easement would be like for money, like if you have like payments or a billboard or something. But you've got an easement appurtenant, easement appurtenant, and that's when usually typically like there's a physical, it's going over the land and it's benefiting one parcel because it gives the, you know, an outlet to the highway or whatever it is. That's the typical one for the bar exam. You've got these easements. We've got our delicate property vocabulary here. Let's talk about an express easement. So an express easement is what it sounds like. It's express. So it has to satisfy the statute of frauds, which means it has to be in writing and signed by the party to be charged. Remember, under the statute of frauds, it doesn't have to be signed by both parties. Only has to be signed by the party to be charged, which is typically like the person who's being sued or whatever. All right, so we've got an express easement. We've got an implied easement. This can be by prior use or necessity. So what kind of easement is this? This arises from severance of commonly owned land. It has requirements. California courts tend to emphasize intent, but let's go through some of these requirements. You've got common ownership at severance. Use or necessity existed at the time of the severance. The use was apparent and or continuous, and it reasonably or strictly for necessity necessary. It's reasonably necessary for beneficial enjoyment of the dominant estate. All right, great. So there's our standards here for implied easement. Let's talk about an easement by necessity. Okay, so an easement by necessity, it's got to have strict necessity. Typically, this means you're landlocked, right? It's a parcel of land with no other reasonable access or way out at the time of severance. So it's, again, you need this common ownership, initial common ownership, and then the necessity continues at severance. And let's talk about the next type of easement, a prescriptive easement. this is like your adverse possession easement. So you've got all the adverse possession elements that you're going to want to walk through. Again, when I did the bar exam, I really tried to put my elements in like the little parentheses 1, 2, 3, 4 format, because I think they will give you, it's easier for the bar grader to see what the elements are, and I think they check off and give you like points if you're making it clear and easy for them to see on the bar exam. And you can name out with, that's where a lot of people use flashcards or like this spaced repetition learning. There's this website called Memrise if you've ever tried to learn a language. It's how you can probably best study for the bar exam. You're going to want to, I tried to do it just like going through it naturally, going through hypos naturally and seeing this stuff over and over again. And through the MBE, it tests this kind of these rules and stuff. But as it comes up, before you look at like the answer, you just want to internally in your head go through and see like, can I check off all the elements? You might miss a few or whatever, but just try and go through like, hey, for prescriptive easement, I've got to have 1, 2, 3, 4-ish, 5 elements that we're going to talk about here. So it's a prescriptive easement. You've got to have number 1, open. Number 2, notorious. Number 3, adverse or hostile. Adverse, hostile. Maybe it's easier to have hostile. Number 4, continuous use for the statutory period. Okay, great. So it's just like, it just works exactly like adverse possession, but it's for an easement. Cool. Let's go into our application here for this bar hypo. Let's get back into it. So there's no express easement. You might just want to just touch on that really quickly. Hey, there's no facts of any written grant from Barry or prior owners to Simon and Olivia. So it looks like maybe the statute of frauds is not going to be satisfied. We move on. Just if there's not a lot to say, just hey, look, there's this express easement. Doesn't look like on the facts that we have a written grant from Barry, so doesn't apply here. Implied easement or easement by necessity. This seems like, probably going to be the strongest claim. So let's go through. Common ownership. Olivia owned both lots A and B before conveying to B 60 years ago. So do we have common ownership? Yes. The dirt road existed across B from A to the highway pre-severance. It was the access route. Okay, great. So is there necessity? Yes, the facts state that, quote, and whenever you get into your application section, I mean, again, this is not a creative writing test. So when you do the bar exam, issue, rule, application, conclusion, you've got issue. I literally say, here the issue is blah, blah, blah. Okay, rule. That's where you get the stuff that you're supposed to memorize. Hopefully you've got the elements down, 1, 2, 3, 4. Application, I always just start with here and then quote the facts. Take your, as you go through the hypo, you're just trying to look for these pertinent facts. That's why reading the questions, I think, helps. It kind of, what you highlight or underline or have in your head, like, these are the important facts. You just drop those in the application section. So here we would be like, here, quote, there was no other access. You just quote from the facts. Lot A would be landlocked without the road. Simon and presumably Olivia used it regularly post-severance. Okay, so necessity existed at severance and continues. Awesome. There, we've satisfied that little hurdle there. Again, if you want to get into the California, how they analyze these, they emphasize giving effect to clear intent for continued use. Seems like maybe we have that on the facts here. Is it apparent and continuous? Well, you've got a long-standing dirt road and regular use by Simon for 29 years to support this part. So looks like for an easement by necessity, we've got everything that we need. We've analyzed through all of the requirements for that easement of necessity, and we'd say, hey, likely there is an easement by necessity. That's going to be your conclusion, but we're going to go through these other ones too. You want to try and go through as many as possible. This is where how you maximize your points here. You're going to be like, hey, no express easement. Okay, there's an implied easement or an easement by necessity. Go through that analysis. It looks like we've got that here. Prescriptive easement. Okay, so Simon has regularly openly used this for decades. It seems like it's hostile to Barry's ownership. After initial permission lapsed, didn't seem like from the facts that it was granted again. So we've got a hostile element, and it likely meets the statutory period. Okay, awesome, because it's a really long time, right? It's like these 30 years or whatever. It's open, notorious, and continuous and hostile. Okay, it looks like we might have a prescriptive easement. All right, so we go into our next vocabulary here and apply it to the facts. You've got an appurtenant and it runs with the land. So we've got here an easement that benefits Lot A. Here, if you look at the facts, Lot A is the dominant estate. It burdens Lot B, so that is the servient estate. So that's how this language gets broken down on the bar exam. They recorded conveyances and put developer on notice here. So they had notice, right? It gave us in the facts. Everything was recorded properly. So Simon inherited Lot A from Olivia. The benefit probably passed with the land. All right, great. So our conclusion here on question 2, Simon has strong claims for an implied easement by necessity. That's probably the primary one he's going to rely on. He hit all the factors there. And or implied easement by prior use, which is kind of in that same ballpark. And or he probably has a prescriptive easement as well, which is that adverse possession one. So here he can seek injunctive relief to keep the road open, right? That's kind of what you're going to do in this case. An injunctive release can stop, injunction can stop things, but it can actually say you have to keep doing something, right? It's just non-monetary. The court's basically an injunctive relief saying you have to do something, like affirmatively. So here he's going to seek injunctive relief to keep that road open. The easement is appurtenant is appurtenant to Lot A and enforceable against current owners of Lot B. All right, man. So we've got our property language, kind of went through it a little bit quickly there. We've got our 2 questions answered, and there's the bar exam question for property. It's a property question from, again, this is California, July 2024, a Rule Against Perpetuities monster. So we've gone through that. We're going to pass the bar exam, and I'll see you guys next time. If you have any questions, let me know. Leave a comment or whatever, and I'll get back to you. Great. I'll see you next time. Happy studying.